Welcome back, class. In this segment, we're going to focus on the chapter that focuses on agreement. So we're going to focus on agreement in this chapter. An agreement is composed essentially of two elements, an offer and an acceptance, right? Which gives us our agreement, consideration, capacity, legality, sort of fully expressed, is offer, acceptance, consideration, capacity, and legality. And again, as stated in the previous segment, an offer is a promise that is supported by proposed consideration. And so we know that not every promise, although it's made in the form of a promise, not every promise is legally enforceable. And an offer is a promise that can be made legally enforceable by the offeree's acceptance. Again, the party who makes the promise is the offeror, party to whom the offer is extended and who has the power to accept is known as the offeree. There are three elements to a valid exception. In order for the thing to be an offer, right? Number one, there must be a serious objective intention by the offeror to be bound by the offeree's response. A serious objective intention by the offeror to be bound by the offeree's response. And this takes us back to the objective theory of contracts, where we look at objective as opposed to subjective evidence to determine the intent of a party, right? Number two, the terms of the offer must be reasonably certain, definite, right? And a court must be able to tell what the terms are so that it could award some type of remedy if this case were to become the basis of a breach suit, right? And third, the offer, in order to be an offer, must be communicated by the offeror to the offeree. All right, those three things: serious objective intent, reasonably certain terms, and communication to the offeree. All right, once that's happened, the offeree's acceptance of that offer creates a legally binding contract, as long as that offer is supported by consideration, which we'll get to later. All right, so again, with this in mind, we should understand that there are certain types of statements which are just excluded from the definition of an offer, right? So, for example, Hawkins takes his son to McGee, a physician, and asks McGee to operate on his son's hand, right? McGee said that the boy would be in the hospital for 3 or 4 days and that his hand would probably heal a few days later, right? The son's hand did not heal for a month, but nonetheless, the father brings a lawsuit, right? The father doesn't win the lawsuit for breach of contract. The basis for his proposed breach was that the doctor said that this would heal more quickly than it actually did. The court held that McGee did not make an offer to heal the son's hand in 3 to 4 days. He merely expressed an opinion as to when the hand would heal. This, our first category, is an expression of opinion incorporated into a contract is not a basis for a breach, right? It's not an offer, for example, to heal your son's hand within 3 to 4 days. A statement of future intent, right? If we have an intention to do something in the future, that statement in and of itself is not an offer. So Samir says, I plan to sell you my stock in Novation Incorporated for $150 per share, all right? If you accept that offer, that's where he says, I plan to sell you these shares at a certain price, there's nothing there to accept, right? Because his plans have not been manifested with a subjective intent to be bound in this present moment. Similarly, third category, preliminary negotiations. So if I want to enter into negotiations, say, I'd like to buy your car, how much would you sell it for, right? That's a preliminary negotiation. You don't come back to me and say, here, I'd like $12,000. It's a deal, right? I mean, you can certainly offer that, right? but that would be an offer, right? It would. It's different from preliminary negotiations where I'm just feeling you out. That's a request or invitation to negotiate. It's not itself an offer. Another category, advertising of any time, of any kind, with an exception, is not regarded as an offer. An advertisement is an invitation to deal. They're asking you, when you look at that advertisement, to come in and make a deal with us, or to make a deal with us over the phone or internet, however they choose to do so. This applies whether the ad is published in traditional media or online, right? So you are the one, when you respond to the advertisement, you are the one making as the consumer, the party that's making the offer is the consumer, right? And I know that feels a little counterintuitive, but it avoids some complications that could arise if every advertisement was an offer, right? There are exceptions in the Uniform Commercial Code and in various jurisdictions. A merchant, one who is engaged in the sale of goods or who is otherwise engaged in business, either goods or services, can hold an offer out, and that offer can be binding upon the offeror, upon that merchant, if they intend to be bound, and it sets forth a time period generally no longer than 3 months. Right? This is known as a merchant's firm offer. It can appear in the form of an advertisement or in some other form. Right? But it's a merchant's firm offer, if it also happens to be an advertisement, will be an offer that is binding on the seller or the offeror in this case. But outside of that circumstance, right, if it's not a merchant's firm offer, that's why, for example, prices may be subject to change just like that, right? A price list is an invitation, for example, to make an offer, but if you get to the store and the price has gone up or down or gone sideways or whatever, the price is not fixed just because the advertisement is in effect, right? Again, with the exception of the merchant's firm offer. And another category I should mention are agreements to agree. So, an agreement to agree on certain terms at a future date. So, if an agreement has certain agreements that are agreements, and then you have certain terms that are maybe as yet to be settled, you can have an agreement that may be enforceable in some cases if the parties clearly intended to be bound by the agreements, right? So you can have, for example, I had a settlement agreement where part of the agreement was agreed, and then part of the agreement was an agreement to agree, right? At a later date, once other facts in discovery had been worked through, but the parties knew that they wanted to agree, right? The fact that there was partial agreement may in fact create an obligation to not be unreasonable in withholding resolution of the remaining points of agreement, right? So, an example, after a customer nearly drowned on a water ride at one of its amusement parks, Six Flags filed a lawsuit against the manufacturer that had designed the ride. The manufacturer claimed that the parties did not have a binding contract, right, but had only engaged in preliminary negotiations that were never formalized into a contract to construct the ride. The court, however, held that the facts document specifying the details of the ride, along with the parties' subsequent actions, having begun construction and written notes on the facts document, was sufficient to show an intent to be bound. Because of the court's finding, the manufacturer was required to provide insurance for the water ride at Six Flags, and its insurer was required to defend Six Flags in the personal injury lawsuit that arose out of the incident. So, just as a clarification of what happened here, right? the issue was not whether Six Flags and the amusement park construction company had an agreement to construct the ride, because they clearly did have an agreement to construct the ride. It's almost whether that agreement possessed sufficient formality, right, for it to be a contract that would be insurable under the construction company's insurance, which is a separate issue, and it's a weird issue to use in the book as an example, because of its, there are other questions that kind of underlie that case, but that's basically what's happened there. So they basically determined that even though they didn't reach a final on paper agreement, their actions, including the implied contract that resulted from the express portions that were agreed to, were sufficient to create that contract, right? And the last category that I'll go into here is preliminary agreements, which are excluded as well from preliminary agreements may be partially enforceable, right? But if the parties have agreed to all essential terms, similar to an agreement to agree, right, then, and there are no disputed issues that remain to be resolved, the court may simply find that the agreement is complete. If negotiations subsequently fall apart, generally this will happen in cases where some portion of performance or some detriment to one party or the other in reliance upon these agreements to agree, or preliminary agreements are in place. So once you experience a detriment, it's more likely that the court will find that there's a whole agreement in place. A preliminary agreement is binding only in the sense that the parties have committed themselves to negotiate the undecided terms in good faith and in an effort to reach a final agreement. All right. So take a look at the prompt in this section, and I will see you in the next. Thank you.